Just before I start, I'd like to join with our fellow speakers and sponsors in condemning the Russian aggression in Ukraine, and offer our solidarity to those suffering in the humanitarian crisis that is unfolding there, and to those harm reduction and HIV prevention services particularly, who are courageously trying to continue their work and ensure the continuation of services to people who use drugs in Ukraine. Okay. Onwards, I'm going to make some introductory remarks before we move on to our guest speakers. So the key aims of cannabis policy should be the protection of public health, the promotion of social justice and equity, and the reduction of drug-related crime. Cannabis policy making should be evidence-based, and policymakers should monitor and evaluate performance against these identified key aims. Cannabis policy that adopts such an approach while seeking to promote social justice and protect public health should naturally guard against excessive corporate influence, which will generally, if not inevitably, preference profit maximization over public health and social justice. It is only concerned with externalities where profits are threatened. The concept of corporate capture, in inverted commas, refers to the means by which corporate entities pursue profit and power by exerting undue influence over domestic and international decision makers and public institutions. Such corporate capture may weaken regulatory powers, as well as undermining the realization of human rights and the environment by exerting undue influence over domestic and international decision makers and public institutions more generally. The mechanisms by which such influence is exerted can include both overt and behind-the-scenes lobbying, including the provision of hospitality, through direct and indirect funding of politicians or political parties, through influencing provision of expertise through funding of think tanks, civil society organizations, and academia, through the membership of government committees or task forces, and through the revolving doors movement of staff between corporate and government posts. Guarding against excessive influence in policymaking necessitates that constraining corporate power more generally, to prevent the emergence of corporate monopolies or market dominance by a few large actors. The history of both alcohol and tobacco regulation illustrates how difficult this can be. But starting from scratch, as would be the case in many jurisdictions for cannabis, offers an opportunity to learn from the lessons from other regulated drug sectors, as well as emerging experiences in legal cannabis markets. It may, however, already be too late to start from scratch, or at least to completely start from scratch. Legal regulation in Canada, for example, has already led to the establishment of several multinational cannabis producers valued in the multiple billions of dollars. While the overwhelming majority of non-cannabis market space is concentrated in North America, the similarity between the medical and non-medical products means that Canadian market actors in particular have been able to seamlessly shift attention to and obtain a stake in medical markets elsewhere. The existence of truly multinational corporations also means that powerful entities are already waiting in the wings to capture emerging non-medical and market space as it develops. Relatedly, the emergence of medical markets in a number of jurisdictions means that market dynamics favoring larger, more established businesses are already evident, given that many of these medical producers and retailers will inevitably seek to expand into the non-medical market space once it is legalized. This may not, therefore, be a completely blank slate. However, the first steps of legal regulation remain a vital opportunity to set goals and parameters, establishing the controls necessary to protect against corporate capture from the outset through initial legislation and regulations. This includes the adoption of equitable licensing policies and social equity programs. This whole discussion assumes, of course, that some level of corporate involvement in the market is permitted at all. However, state monopoly control over elements of the market remains a viable and important option, and one that would, by removing involvement of corporate actors, thoroughly deal with the concerns over corporate capture, at least in those monopolized elements of the market. For this and other reasons, state monopolies over parts or all of the market should be given serious consideration. And Transform, my organization, have recommended, at least as a strategy for the commencement of legal markets, that state monopolies be explored while new norms are established. Now, the blank slate offered by legal regulation can be muddied by existing medical cannabis markets. For jurisdictions with existing medical markets that wish to promote equitable market access, there is inevitably an unequal playing field, given some businesses are already well established, licensed, and experienced at producing or retailing cannabis products. New actors looking to break into the market will face strong competitive disadvantage, potentially requiring intervention to re-level the playing field. This is a key tenet of promoting equity and ensuring a diverse market. Most US states that have legalized non-medical cannabis have done so with pre-existing medical markets in place. Since legal regulation creates new administrative burdens, some states have implemented strategies which either directly or indirectly favored medical businesses. Such strategies simplify the administrative process. However, they also create significant barriers to diverse participation in the market and potentially limit access to local small businesses who may well represent local communities more closely than larger operators. There is clearly some merit to preferential treatment from an administrative perspective. In some states, such as Michigan, this approach has allowed non-medical sales to begin relatively quickly once licensing applications opened. But unless social justice and equity were key goals in the medical licensing undertaken beforehand, the favouring of existing license holders is unlikely to promote these outcomes. This is likely to be a bigger problem where medical markets are more established, have existed for longer, or are larger in size. Similarly, large, well-established medical markets may lead to other licensing challenges. The long-established nature of the California medical market actors has been linked to an enduring grey market, where relatively light-touch state regulation or tolerance policies meant medical provision acted as a retail proxy for non-medical consumers. In this concept, the aim of legal supply chains to capture the market has proved challenging, even after licensed non-medical sales were able to begin. Where established grey markets already exist, licensed producers are almost retroactive in nature. Licensing of procedures, rather, are almost retroactive in nature. Sales have already been tolerated for long periods of time, but now market actors are required to engage with often complex licensing procedures with little incentive other than the sudden threat of enforcement to perform the same activities. As markets develop worldwide, many large cannabis corporations are seeking to establish themselves in existing medical markets, speculating that future legal regulation may offer lucrative opportunities for those first through the door. Experiences in the US suggest this may be a worthwhile strategy from a business perspective. From a regulatory perspective, however, these experiences highlight the need to pursue strong and effective licensing policies from the outset. Allowing established players to entrench and corner these markets, especially ahead of full legalization, risks negating social equity measures later on. There is well-documented history of powerful alcohol and tobacco industry actors deploying legal, PR, and lobbying resources to undermine efforts to restrict or regulate their activities, and seeking to undermine research evidence that supports stricter regulation. Any regime of regulated drug markets has to be designed to mitigate this risk and to be robust enough to resist the intense pressure that powerful commercial players are able to exert. Indeed, many of the largest alcohol and tobacco companies are seeking to become key players in future cannabis markets. This should be resisted with the regulatory measures in place to prevent or limit their involvement. And I think Shaleen will probably be talking a little bit more about this in the future, later in the webinar. The experiences of Canada are instructive for a number of reasons. Firstly, Canada, with a population of nearly 40 million, was the largest nationwide cannabis market at the time of its inception. While Uruguay regulated cannabis earlier, it has 1/10 of the population size. Federal illegality in the US means that, despite the existence of multi-state operators, cannabis is effectively managed in a series of internal state markets, with import and sale between states still remaining illegal. Secondly, if cannabis businesses, Canadian businesses, more than any others that presently dominate, that it is Canadian businesses that more than any other currently dominate international cannabis markets. And finally, it is clear that Canadian regulation, for all its many merits and successes, did not do enough to guard against corporate capture from the outset, or maximize the opportunity to start from scratch with a new market commodity, in part perhaps because so many actors already operated in the existing medical market, and that this has led to a concentration of the market share and accordingly power amongst a select few actors. The emergence of the cannabis market in the non-medical cannabis market in Canada in 2018 contributed to the so-called green rush amongst stock market investors, with huge investment pouring into what was seen as a potentially profitable new commodity. Following legal regulation, a number of federally licensed producers benefited from large, mainly speculative investments. Heavy early investment was scaled back once the market picture became clear. However, the stock prices dropped dramatically in the second half of 2019. Despite the hopes of the introduction of micro-cultivation licenses would be open the market to smaller producers in Canada, this has not really been the case. In 2019, the federal government announced that in order to apply for a license, potential suppliers are required to already have a production facility in place. This meant that those unable to risk the initial investment costs, running into tens if not hundreds of thousands of dollars, were deterred from applying. Although 300 micro licenses have now been issued and some barriers have been reduced, initial restrictions have contributed to an emerging market that is still dominated by a relatively small number of large corporate actors. The majority of money in the market is being made by these large producers, who are licensed at a federal level and whose products can be sold by retailers across the country. In comparison, retail is managed by individual provinces and territories, some of which do not allow private retail actors at all. In some provinces, however, the potential for cannabis corporations to dominate the market at a retail level is limited by regulations. In Alberta, for example, individuals or groups of persons are not allowed to hold more than 15% of total licenses at one time. Again, I think this is something that Shaleen will be touching on later. This kind of license limitation is vital to prevent monopolies and to facilitate wider market access. In recent years, Canadian companies have also established a strong base for international expansion. So far, this has mostly been involved capturing medical market space. Nevertheless, diversifying from medical to non-medical is relatively simple. This is particularly the case given that many Canadian producers were, prior to October 2017, already licensed producers in the Canadian medical market. We are therefore seeing Canadian companies flush with speculative capital investment globalizing quickly. Canopy Growth already has established medical presence in Australia, Europe, Africa, and South America, while Kronos Group similarly operates across 5 continents. This has left Canadian companies in a strong position to take first advantage over potential cannabis legalization. And there are many examples of this playing out across the world, Latin America, and beyond. And I think we'll hear some more from this from Lisa shortly. Market capture by Canadian companies in South America has particularly drawn criticism. The Colombian Association for Cannabis Industries has estimated that medical cannabis companies in Colombia are nearly 75% owned by foreign investors. In 2018, Canopy Growth purchased the Colombian company Spectrum Cannabis for $60 million. Elsewhere in Latin America, Aurora Cannabis, which has been an investment of 25 companies, purchased ICC Labs in 2018, obtaining over 70% of the market share in Uruguay in the process. While South America has drawn the majority of attention at present, this will no doubt be an issue elsewhere going forward, including in the emerging markets in Europe in particular. Canadian companies have also been quick to exploit the opportunity created by legalization of medical cannabis production in Lesotho, with multi-million-dollar investments in local farms and companies. All of this raises important questions going forward on how markets should be structured, how traditional cannabis growing communities can be protected, and how fair trade and sustainable development can be guaranteed in emerging markets. Without positive action at an international level, there is a real risk that the long-term outcomes will benefit corporates located in the global north over the interests and well-being of communities working in the global south. New cannabis markets have presented opportunities for actors in other sectors, including alcohol and tobacco companies, to diversify into the cannabis space. This raises obvious concerns, especially given the long history of tobacco and alcohol industries lobbying against public health regulation. Tobacco and alcohol not only bring enormous financial muscle, but decades of lobbying and PR expertise, which can be deployed against regulation geared towards both public health and social equity. And we'll be hearing from Benoît a bit more about this shortly. Altria, one of the world's biggest tobacco producers, has invested over $1 billion in the Kronos Group, where it now owns a 45% stake and has 3 out of the 7 seats on the board. British American Tobacco brought £120 million stake in the Canadian producer Organogram, and there are many other examples. Cannabis investment has now become mainstream, with big shareholders in Canopy Growth, including Morgan Stanley and the Bank of Montreal. Major shareholders in Aurora Cannabis include JP Morgan and Norges Bank. Government Pension Fund Global, which invests in Norway's oil and gas resources. There's also been a development in cannabis exchange traded like Alternative Harvest ETF, which invests heavily in Canadian cannabis companies. A key theme of Transform's work has been to learn lessons from the early adopters of cannabis regulation in order to improve our regulatory practice. While in the US states, Canada and Uruguay operated largely from a regulatory blank slate, future regulatory models have had their experiences to learn from. We have seen how quickly the combination of massive capital investment and weak or naive regulation can lead to suboptimal outcomes. Future regulation needs to create a better balance between lifting restrictions of prohibition and ensuring that new markets promote social well-being. If policymakers wish for an equitable distribution of market space, which we believe they should, then they must act from the outset to prevent corporate capture, avoid monopolization, and actively promote market access to smaller and marginalized actors. The potential for equitable licensing policies and the utilization of social equity programs is discussed in detail in our other literature, but it is broadly applicable at the production level too. The benefit of starting from scratch or largely from scratch should not be underestimated, and attempting to retrofit equitable mechanisms is much more difficult. Where larger corporate actors are involved in domestic and international markets, as is already happening and remains inevitable to some degree, it will be important to ensure minimum standards of transparency and accountability regarding corporate lobbying and other forms of influencing policymakers to prevent undue influence. Measures should include fully transparent registers of all lobbying of policymakers and officials, strict rules for lobbyists and think tanks, including transparency of funding sources, and comprehensive freedom of information rules and restrictions on corporate and political funding and hospitality. There has been a great deal of public health research in recent decades highlighting the failures of regulation in relation to corporate capture of tobacco and alcohol. Generally, we have been too late to learn the lessons in these areas, and realigning markets towards a public health focus has been all the more difficult as a result. We must ensure that this doesn't happen again for cannabis. So that's the end of my introductory remarks. I would now like to introduce Benoît Gomis, who unfortunately is in the other side of the world and is coming to us a pre-recorded video. But Benoît is a lecturer at the University of Toronto's Monk School of Global Affairs and Public Policy and a research fellow at Simon Fraser University. He works with a number of organizations, think tanks, NGOs, companies, universities, and he's got a dazzling CV. I think I'll just let him introduce himself. Over to you, Benoît, on video.
Hi, everyone, and thank you so much, first of all, to the Commission on Narcotic Drugs for giving us this opportunity to talk about such an important topic. Thank you to my colleagues for putting together the event. I'm really humbled to be part of such an inspiring group of speakers. So thank you. And thank you all for tuning in. I'm very sorry I'm unable to join synchronously, but I thought I would spend the next 10 minutes or so to lay out why I think there is much to be learned for cannabis regulation from the tobacco experience, especially as it relates to the illicit tobacco trade and the role of the tobacco industry in it, both in its complicity in illicit trade, but also how it's managed to capture a lot of the law enforcement and government response to this illicit trade and the media and academic discourse around it as well. So this talk builds on a report that IDBC published in partnership with Health Poverty Action, Transform, Transnational Institutes, WOLA, and GDPO, which I recommend you read. But of course I would say that, wouldn't I? So in the 1990s, we found out that big tobacco companies had been, since at least the 1960s onwards, directly involved or complicit in smuggling their own products. Why would they do that? Well, for a number of reasons, and here I'd like to highlight three key ones. Number one, to increase their revenue and profit, as they anticipated a decline in revenue following reports, including from the US Surgeon General, on the health harms, the severe health harms caused by their products. Number two, to enter new markets that were at the time protected by trade barriers and other protectionist measures. For example, British American Tobacco and Philip Morris International, BAT and PMI, exported billions of cigarettes to Paraguay legally, despite a very small local market, to actually then smuggle those cigarettes to the protected markets of Argentina and Brazil, all the while lobbying those two countries' governments to open up their markets telling them, look, your populations love our products so much that they're actually importing them illegally. And while, of course, putting pressure on domestic companies as well. And number three, to circumvent, to go around existing public health measures and to effectively lobby against them. Canada is a great example of that. In the early 1990s, big tobacco companies shipped cigarettes legally to the US for these same cigarettes to be then smuggled back through First Nation reserves to Canada, while at the same time putting pressure on the federal government of Canada to decrease taxation to deal with this growing illicit trade that, again, they were themselves leading. So it worked from an industry's perspective and led to tens of thousands of additional smoking-related deaths in the country in just a few years. Until the smuggling scheme was uncovered. But as a result of the smuggling that big tobacco companies around the world were found guilty of in the 1990s, early 2000s, many of them actually entered into formal and informal partnership with national governments and international government organizations worldwide on how to tackle the same illicit trade they were themselves found responsible for largely creating in the first place. So as my colleague at the University of Bath, Anna Gilmore, and others have noted, Big Tobacco spent the next few years rebranding themselves from perpetrators of the illicit tobacco trade to victims of and solution to the illicit trade. And from a commercial standpoint, they've been largely successful in many ways, by providing law enforcement revenue and customs agencies with equipment, money, information, and intelligence on competitors, with advice on how to conduct law enforcement interventions, with training on how to investigate the illicit trade, and so on and so forth. We've seen, for example, a few months ago, Philip Morris International receiving an award from the US Department of Homeland Security for their efforts in tackling illicit trade. This including a training program for US law enforcement. But peer-reviewed analyses of Big Tobacco's anti-illicit trade strategies and tactics have found that these efforts have been largely ineffective in reducing that illicit trade, in large part because they were not designed to truly address the illicit trade, but rather to, one, grow those companies' revenue and profit, number two, to steer attention away from their own complicity, and number three, to increase their influence on public health policy making. The most blatant recent example of the length big tobacco companies are willing to go on this issue centers perhaps on BAT, or British American Tobacco, in Southern Africa. I was lucky to be part of a consortium with University of Bath, BBC Panorama, and the Bureau of Investigative Journalism, which found that BAT hired over 200 private security agents across the region to spy on competitors, to disrupt their legal manufacturing and distribution processes, and even negotiated a bribe for Robert Mugabe on an anti-illicit trade issue. All of this while co-opting law enforcement agencies and remaining complicit in smuggling themselves. So big tobacco companies have also funded research projects, influenced media stories, lobbied government officials through third parties and front groups, and used other tools to steer attention away, once again, from their own complicity in the illicit tobacco trade, to exaggerate the size of illicit tobacco markets, and to incorrectly characterize illicit trade as an issue primarily related to taxes being too high, or due to other tobacco control measures. The cautionary tale here, or warning sign for cannabis regulation, is that with inadequate regulatory frameworks that prioritize commercial interest over public health, social justice, sustainable developments, and human rights, and other key principles that IDPC eloquently laid out in this September 2020 report, we run the risk of ending up with a big tobacco-like cannabis industry. Now, an important note here is that cigarettes are incredibly harmful, killing between half and 2/3 of their users, and 7.7 million people worldwide in 2021 alone. In contrast, cannabis presents low health risks and some health benefits. But given the large investments that big tobacco companies have already made in the cannabis industry, including in Canada, given the similarities between the two products and the two supply chains, given that many former big tobacco executives now hold senior roles in the cannabis industry, given the powerful business and political pressures in favor of commercial models instead of nonprofit ones, given some of the significant problems with the seed to sale or track and trace systems that have been put in place to track and trace or monitor cannabis products from production to consumption, and in theory prevent diversion from the legal to the illegal supply chains, I strongly believe there is much to be learned from the tobacco experience in terms of how to set up effective regulatory frameworks. So again, I'm glad we're moving away from the binary debate of whether or not to legalize cannabis and to the nitty-gritty of how to do so in a way that supports the principles of public health, social justice, human rights, and sustainable development. But I hope that this conversation on corporate capture can be an opportunity to bridge the existing gaps with researchers and advocates in the tobacco community and the so-called commercial determinants of health, on the one hand, with those involved in cannabis and drug policy reform. So again, thank you so much for listening, and let's keep this conversation going. Thank you.
So our next speaker is the amazing Shaleen Title from the USA. She's an attorney and drug policy activist who's been writing, passing, and implementing equitable cannabis laws for over 20 years. She was a top cannabis regulator in Massachusetts from 2017 to 2020, and currently serves as the CEO of the Parabola Center, a think tank creating drug policy free of corporate influence. She's testified before government bodies around the world about reparative marijuana laws. And in 2021, she authored papers on social equity and anti-monopoly cannabis policy published by the Ohio State University Drug Enforcement and Policy Center. Dubbed the People's Weed Watchdog by Boston Magazine, she's a recipient of multiple Lifetime Achievement Awards and a business degree, law degree, and graduate degree in accounting from the University of Illinois. And basically, she's an all-round legend. And she's now going to tell us, I think, a bit more about that recent report on anti-monopoly cannabis policy published recently. And we'll share the link in the chat. Over to you, Shaleen.
Thank you so much. Thanks, everybody, for joining. I want to start by just saying how much I appreciate the work done by the organizations on this panel and people who may be watching. I don't get that opportunity very much, but as a regulator, it was so helpful for us to have reports by groups like Transform and by all of the groups that have watched other industries, specifically big tobacco, so that we can learn those lessons, do everything we can not to repeat them. And then now I would say we're trying, at least on my own behalf, we're trying to pay that forward by being very clear about the lessons that we've learned so far and make sure that new jurisdictions that legalize cannabis or other drugs won't have to learn the lessons that we have. I think also it's important to note that we are not powerless. If you look at what is actually happening in the places that have legalized cannabis, a lot of these corporate capture attempts have not been successful. When I was a regulator, I was on the receiving end of many unsuccessful attempts at corporate capture. And as a regulator, I would say that there's been really good progress, especially on reducing youth access and making sure that youth access doesn't go up. And making sure that we have advertising that doesn't target kids. we have to preserve that progress and make sure that we don't lose it as the industry grows. I think Steve covered corporate capture really well, but I want to emphasize a couple of things before I move on to most of my presentation, which will be explaining solutions that are laid out in this paper I did with Drug Enforcement and Policy Center. So one thing is I want to flag how important timing is, because I didn't know this before legalization. It's something that we observed. And I think it's because maybe it hadn't happened in other industries, because it is so unique that we had companies that were in the medical market. And then in many cases, jurisdictions tried to become more equitable and more social justice focused as they transitioned to the adult use market. And that was kind of unique in the sense that the existing medical operators were able to successfully in many places get an early start in the market, get essentially an oligopoly, because they would go in and say, we need to keep the market small, we need to keep it controlled, let's only have 10 licenses throughout the state, for example, and let's make sure that they go to us. And that proceeded to have a lot of problems and going in the direction of an industry where companies could get so big that you can't effectively timing. Because now what we're seeing is not only should you only have a few licenses, they say, but you have to speed up the market. And if you don't speed it up, we're going to have all kinds of problems. And therefore, regulators can't take the time that they need to set up an effective regulatory system. You need to do it now, now, now. And they have all sorts of reasons for why, coming from all different messengers. But one very recent one I've noticed that's not in my paper because it's so recent is that we're actually starting to see that message coming from law enforcement. In Connecticut here, very recently, there was a police department that said the dispensaries needed to open as soon as possible because there was concern about fentanyl-laced cannabis. That was something that was later debunked. But I wanted to flag that because it's very important, I think, to be vigilant and to look for these things coming from any possible messenger and not just from the corporations themselves. So with that, let's turn to solutions. As I said, we are not powerless. There are so many organizations that are working on effective regulations that are not dominated by corporate influence. And in my experience, working with the cannabis legalization and regulation movement, the vast majority of the people in the movement do not want to see domination by big corporations. And so if you have a solution and you have a path, that's where they will want to go. In fact, that's my experience with governments as well. So there are 8 solutions laid out in this paper. It's called Bigger is Not Better, Preventing Monopolies in the National Market. It's available free, open to the public from the Ohio State University Drug Enforcement and Policy Center. And I'll go through the 8 solutions that are laid out there. Number 1, allow people to grow a reasonable number of plants for personal use. And by personal use, this can include social sharing with no payment involved and home cultivation. The reason that's important in the context of anti-monopoly and corporate capture is because it provides a check on what you're seeing sold in stores, especially if that's very limited. And if we were to see something similar to big tobacco, where the product is being manipulated to become potentially more addictive or more harmful, there's a check because you also have the option to simply grow your own at home. And it provides a check on pricing as well. The second is to prohibit vertical integration. So vertical integration means when one company controls the entire supply chain, from when the product is grown, when it's processed, say into edibles or other products, and then when it's sold at the retail market. So when I interviewed people who were not cannabis experts, but were anti-monopoly experts or corporate capture experts in other industries. That was the time-tested, common sense solution that most of them gave first, is if you don't allow a company to control all of that, it's much better. And that's a lesson learned from alcohol. And if you do already have vertically integrated companies, which some states do here, that could potentially be spun off in the way that other monopolies have been addressed in the past. The third lesson or solution is do not cap the number of business licenses available in total, but limit how much of the market one entity can control. And if you only take away one solution, make sure it is this one, because it is applicable to each and every jurisdiction, whether you're at the city or state or province level or the federal level. And it's a very early decision that you will have to make. So the worst possible thing that you could do is have a small number of licenses available and then not cap how many one company or one entity can control, because you are immediately creating all of the circumstances to have companies that are too big to regulate. So instead, if you want to get at the solution of not letting a market grow too big too quickly, there's a number of ways that you can do that. But I would start with, and this is in the interest of social justice and small businesses and disadvantaged businesses, making sure that there's a limit. So here in Massachusetts, you can only own or control up to 3 of any type of license, and that is enforced very strictly. Other recommendations relate back to this one, but this is the biggest. Number 5, enforce ownership limits and review mergers based on existing evidence of predatory and anti-competitive tactics in state marijuana markets. So this is a recognition that the last solution will only be useful if it's in practice and not on just on paper. So it does take investment to investigate and make sure that there aren't shell companies, there aren't loopholes that groups are trying to find, and that their tactics evolve. And so you have to stay vigilant and be a welcoming regulator or government for whistleblowers, collaborate with other regulators about the tactics that they're seeing, and basically make sure that you're enforcing this in practice. I think that's just as important as public health or public safety or the other things that you plan for when you legalize cannabis. Number 6, disqualify corporations from the cannabis industry if they have engaged in corporate crimes, defrauded the public, or caused significant public health damage. So this is actually the reason why we started Parabola Center, because it seemed like such an obvious solution. And you can tell from Benoît's presentation why you need a control like this. I spent 3 years, and even before that, more time when I was practicing law, telling people who had marijuana convictions, I'm sorry, you can't be in the marijuana industry because the law forbids you, and that's the end, you know, and that was it. That was the answer that I gave them. So why can't we do the same thing for the companies that have been found to write the playbook on undermining and fighting effective regulation? And really, you don't see that. We hadn't seen that talked about much. So we wrote that model. It's at parabolacenter.com/resources. And I think it's a very effective, straightforward solution, especially to start. Number 7 is to create a multi-agency task force to enforce anti-monopoly limits. And this is, again, a recognition that you have to invest in anti-monopoly limits. You can't just pass them and then not put in the work to enforce them. And I have more language and examples in the paper. And then lastly, authorize states to ban or delay interstate commerce in order to preserve state-level advantages to local businesses. So that's specific to the US, but to make it broader, the concept here is that when you have smaller jurisdictions that are making decisions about legal cannabis, there is always going to be some independence there. So you want to make sure that, for example, city officials are educated, that they have the proper resources, that they have the proper time to make effective regulations, to make effective selection decisions about what businesses will be operating there, because they will definitely have lobbyists from those corporations that are talking to them. So they also need to have access to unbiased information. And if you let a lot of different jurisdictions, I think, try this, then we will have experiments that work. We will have data that we can compare. Here, if you look at New York or New Jersey, they're likely to be the places where we will see effective solutions and data that supports what we can do to support historically excluded people who want to be in the industry, social justice focused regulations, sustainable solutions, what probably all of the organizations here in the audience are trying to work on. You can find those solutions if we keep trying in different jurisdictions and keeping effective records. So that's what that recommendation is getting at. I hope that was helpful. And thank you again for having me as a part of this event.
Shaleen, that was absolutely brilliant. It's really good to have some clear, practical tips and ways forward for other jurisdictions that are coming to this policy area. And Shaleen's brilliant report, I think we've put the link in the chat. And if we haven't, we will now. Okay, so our final speaker, just to say, I'm conscious that we're probably running over a little bit, but I didn't want to interrupt Shaleen because she was so good, or myself for obvious reasons. So we will probably run over a little bit. If any delegates at C&D need to move on at 5 past, just to say this will be recorded and available online, so we won't begrudge you if you leave. But 50 minutes, it's kind of mean of C&D to only give us 50 minutes. So if we run over a bit, it will be recorded and you can catch up with that later. So next, I'm going to queue up Lisa Sanchez, a long-time colleague of Transform, who is currently the director of the Mexican NGO Mexico Unido Contra Delincuencia, formerly having served as the director of the drug policy program. She's previously worked for an incredible range of organizations, including the Inter-American Drug Abuse Control Commission at the OAS, the youth aid organization Espelea, the International AIDS Society, and the Mexican Consulate in Paris. And she did her master's in science, public management and governance at LSE. Over to you, Lisa.
Hi, my name is Lisa Sanchez, and I'm the director of a Mexican NGO called Mexico United Against Crime. I would first like to thank the organizers and my brilliant colleagues for having me here today. It's really exciting to be part of this side event and to talk about the Mexican experience, but it's even more exciting to be able to learn from my colleagues here, so it's a true honor to share this panel with such amazing people. As you know, I'm here to talk about the Mexican case. So in that regard, let me start by saying that drug policy reform in Mexico is not necessarily a new topic. And to the contrary, it has been present in the political and legislative debates at least since 2007. Pretty much we started this conversation in this country driven by the perception that the negative consequences of prohibition actually outweighed its benefits. And therefore, social movements, NGOs, academic institutions, and even some political leaders have engaged and actively advocated for legal regulation of all drugs, starting, of course, with cannabis. Legislative productivity in this respect has significantly increased over the past 15 years. And as an example, one can say or see that from 2006 to 2012, only 4 bills were tabled to Congress to legalize and regulate cannabis, but that 2012 to 2018, that number reached 32 different bills. In addition, since 2013, Mexico has benefited from a strategic litigation process or effort that resulted in 5 rulings of the Supreme Court, where the court basically acknowledged that the use of cannabis by adults is protected by the right to develop one's personality. Such rulings that we actually managed to get from 2015 to 2021 led to the generation of jurisprudence, and soon after to the declaration of inconstitutionality by the court, which is a process by which the court can mandate Congress to change the law and allow for the regulation of the entire market of cannabis. It is precisely in this context that 2 crucial advances took place in Mexico. First, the approval of a legal reform authorizing medicinal cannabis, and second, the discussion of such bill intended to regulate the entire market for all uses. However, this particular process of having legislation has not been free from corporate interference, and that's precisely what I want to show you. So let's get started with the medicinal cannabis process that basically was approved in 2017 by the Congress and was basically the result of a long time work of civil society organization, and also the result of another strategic litigation process that created some sort of exemptions for patients to access medicinal cannabis. The law passed that year, however, did not ensure the access of patients to medicinal cannabis, and this was mainly because of the industry's interference with the process and the interference of other conservative actors that basically lobbied in favor of extreme restrictions, like the impossibility to develop a national industry here in Mexico, or even for patients to use non-pharmaceutical preparations. These reforms were also hampered by the collusion between certain businesses and corrupt authorities who took advantage of the situation and pretty much started issuing commercialization licenses under illegal guidelines. And thanks to them, large companies have passed off commercial products such as cosmetics, food supplements, and even sweets as medicinal products. Luckily, we had a new government that came into power right after that in 2018, and such government recognized that these guidelines were illegal and started revoking the previously granted licenses. One can think that that was the end of the story and that it was great news, but although the cancellation of these licenses was a good thing to do, the issue of new legal and adequate guidelines didn't come until 2021. Delaying even more the right for patients to access the plant and their medicines, and allowing for the ill-regulated products to remain in the market up to now. In addition, when the federal government, the new one, finally issued the new guidelines for granting licenses in 2021, these regulations failed to correct the wrongs caused by the previous interference of the industry, and the result was the creation of a medicinal or a medical cannabis market that pretty much limits the participation of private actors and social actors to large pharmaceutical companies, forces the importing not only of seeds but also of final products, and imposes heavy restrictions to patients, facilitating business mainly to foreign companies. So that is kind of like the sad story of the medicinal reforms. But now, as the second part of this talk, I want to let you know what happened with the recreational discussion or the process for regulating other uses for cannabis. So as I mentioned before, the process for regulating cannabis for other purposes than medicinal started with the Supreme Court declared unconstitutional the absolute prohibition of cannabis in 2018. And right after that, we started seeing the first initiative or bill to regulate the cannabis market appearing in the Senate. No? So after these bills came, there was one that was tabled to the Senate, and this particular bill was not adopted, and instead a different one was discussed, modified 1 billion times, and finally voted in the Senate in November 2020. After its approval in the Senate, such bill was then sent to the lower house, where it had to be discussed and approved, and it was but with many modifications. And those modifications made it impossible for that law to be enacted because the Senate refused the new bill, and therefore cannabis regulation remained in legislative limbo since then. As a result, adult use of cannabis in Mexico remains illegal, and paradoxically, we owe much of this paralysis again to corporate interest, because since the beginning of the legislative discussion, they started interfering over and over again with the process by, for example, drafting themselves the law or watering down control measures in the different drafts or in the different versions of the bill. And among other things, they actively lobbied again and opposed measures to avoid, for example, vertical integration, or they rejected the inclusion of small producers or disregarded other social justice retributions for indigenous people, peasants, and growers, for example, who were given access to 40% of the licenses to grow cannabis in the original proposal. They also didn't like restrictions for junk food or tobacco companies to participate in the new cannabis market, or the prohibition to advertise cannabis-infused products directly to children and adolescents. On the final draft of the bill, they managed to include restrictions for cannabis clubs, for example, have excessive entry barriers for small businesses, for indigenous communities and growers to participate in the new market, and to impose disproportionate economic sanctions for those in breach of the new regulatory requirements. So as you can see, the battle is not over, and cannabis regulation is still to be conquered in Mexico, and it has to be conquered from a social perspective. That is our job as human rights advocates, to make it work for the people, not only for the industry. And I hope this particular experience helped you think how you can better contribute to an adequate cannabis regulation legislation in your own country or in other parts of the world. So thank you again to the organizers for having me here today, and thank you so much for listening.
That was fantastic to see that, hear that from Lisa, just to see, you know, the reality of these things on the ground. The organization that actually helped get cannabis legalized in Mexico, now having to fight this rearguard action against these corporate influences, trying to sort of derail what MUCD view as good policy, and I think most of us would agree is good policy making. We have gone over time, so I will excuse anyone if they need to leave. This will be recorded and it will be available online later. I would like to do some Q&A, so I'm going to go over our time a little bit. And if anyone wants to catch up later, you can do that with the recorded version. But in the meantime, we're going to break the rules. Break the rules, feels good. And go a few minutes over time, because I would like to ask a couple of questions to Shaleen, who hopefully is still with us. Shaleen, in terms of your experience in the US, which is a few clicks ahead of where Lisa is in Mexico, you've heard from her the challenges that they've had as a fairly limited group of civil society organizations up against these kind of corporate monoliths and their amazing kind of lobbying power and resources. You know, how can civil society organizations compete against that sort of the lobbying might of these multi-billion-dollar corporations? How's that played out sort of on the Hill or in the state legislatures? Is there any lessons from the US that might be relevant around the world?
Yeah, I think the big and obvious and maybe even cliche answer is to unite. But let me tell you what that looks like in practice, because I've seen it successfully. I think that when you have a lot of small groups with kind of their own incentives, you can forget how similar your incentives are. So for example, here, small businesses, local farmers, people who have been harmed by the war on drugs, women, you know, minority-owned businesses, they all kind of have the same goals of wanting to make sure the industry isn't dominated by large corporations. And so I've seen when they're able to unite, get on the same page, and then of course use the resources that are provided by organizations like yours and everyone here, that can be very, very effective, because it looks like and it's true, you know, that almost everybody believes the same thing. And can use the same kind of tactics, and then always watch what other jurisdictions are doing, you know, and learn from their solutions. That's really effective too. Cool.
Yeah, I mean, it does sometimes feel like a bit of a David and Goliath scenario, but David did win, actually, didn't he, in history? I believe it's in the Bible somewhere. There was one other question I wanted to ask you. It's something that I know that you've written a little bit about in recent months. Is there a risk that some of the federal level reforms could potentially undermine or derail some of the positive developments that are happening at a state level? And I guess the reason I ask that is that you know, that although obviously the US federal state dynamics are different to other places, we do have these, you know, within the EU, there's the EU and then there's member states, and there are these other regional and multilateral bodies that will be interacting with state level or member state level dynamics as well. So I was just wondering if there was anything, some of the work that you've done around that recently, if you had any thoughts or lessons from that.
Yeah, I think it's counterintuitive. I didn't even realize this until the past year or two, but certainly here, the fact that cannabis is federally illegal and some of the stigma and obstacles have actually prevented large multinational corporations from entering the market. And it has also allowed states the opportunity to try progressive, sustainable, hopefully, solutions in a way where you're not being challenged by big corporations coming in. So that's a really unique set of circumstances to allow us to try to use those tactics. But once federal legalization happens, I don't think people understand, you know, the way that dominoes will fall will no longer have that opportunity. So it's really, I think the applicable universal lesson is to make sure that you don't assume what's happening now is going to continue, but you're really watching what will change as different jurisdictions do different things or different levels.
Brilliant. Thank you so much for that. So I am slightly over time, and with apologies for the technical issues earlier and me not turning mute off. I mean, schoolboy error. Luckily, we did get through it all, and hopefully everyone saw that. But as I said, it will be recorded if you missed any of it. I think in terms of the concluding comments, really, I just go back to where we started. That corporate capture, it is a legitimate danger. We've seen that with the alcohol and tobacco industries in the past, how it can distort policymaking processes. But we do have this amazing opportunity with cannabis to design the markets and the market architecture around them, the legal architecture around them, in ways that can serve our shared goals in terms of public health and social justice and sustainable development, crime reduction and protection of vulnerable populations. So we do have this opportunity, but we need to grasp that opportunity now. The window of opportunity is growing smaller each day. It's far harder to try and impose these sorts of controls on an established market or reform laws once they have been legislated. So our window of opportunity, really, particularly given the kind of green wave of reforms that's unfolding in across Europe and the world now, our opportunity is now. Our power as civil society organizations who are speaking to and engaging with member state delegations and national governments and multilateral forums is when we stand together united on this, as Shaleen made so clear in that final intervention. So on that note, I'm going to wind up. Just to say, I will post a thread on Transform's Twitter feed with links to all the relevant documents that have been mentioned in this session, and again, and also a link to the recorded version of it on YouTube. And on that note, I bid you farewell. Enjoy the dying hours of the CND, and I hope to see you all again soon. Thank you very much.